Good afternoon, everyone. As promised in my last lecture, today we are going to talk on Nursing Home Registration Act. This act was enacted in 1949, and when it was enacted, its name was Bombay Nursing Home Registration Act. During the last amendment, which was done in 2006, it was renamed as the Maharashtra Nursing Home Registration Act. So, today we are going to see the various provisions of this act. According to this act, in the section 2, various definition has been prescribed. So the important definition is definition of local supervising authority. Means this local supervising authority acts as a nursing home registration authority, and this provides registration to the nursing home. So according to the clause, these clauses, for the municipal corporation area, means metropolitan area, the health officer of the concerned municipal corporation will act as a local supervising authority. And for the municipal council, uh, the civil surgeon of the concerned district will act as a local supervising authority. For the cantonment area, the health officer of the concerned cantonment will act as the local supervising authority. And for other areas, means rural areas of village panchayat and other, the DHO of the concerned Jilla Parishad will act as a local supervising authority. But practically, in fact, what we see that this for this other area also, the civil surgeon of the district act as a local supervising authority. Means even for the rural area, civil surgeon is providing nursing home registration certificate. Uh, this is practically happening, but actually legally it is incorrect. Again, the section 3 of the act says that there is a prohibition to carry on a nursing home without the registration. And section 4 deals with the application for the registration. And this application has the applicant has to apply for the registration or renewal of the registration every year to the local supervising authority. So in this section 4, the word every year has been used. Why it is used, I don't know, because later on there is a provision that uh, so uh, to the this application needs to be done to the local supervising authority, and the application form and the fees and date will be as prescribed, means which will be prescribed later on. This is the process of registration which is prescribed in the section 5. So on receipt of the application, the local supervising authority will issue a registration certificate subject to the provisions of this act and rules. And this authority can reject the application for registration on the following grounds. These grounds are applicant or the employees of that applicant, means employees of that nursing home are unfit. Again, there is absence of registered medical practitioner or residential medical officer in required number or of qualified nursing staff. Means if that nursing home doesn't have the registered medical practitioner or residential medical officer or required number of qualified nursing staff, then the that's local supervising authority can cancel or can reject the application of registration. Again, absence of qualified midwife in case of maternity home. Then area of premise is less than the prescribed area. There is a certain area prescribed for the nursing home, which we will see later. Then number of beds available are more than the prescribed number of beds. Means in the nursing home in the application the number of bed is written as 10, and actually there are more than 10 beds. Then also that local supervising authority can reject the application of registration. And the nursing home is owned or under the management of the government medical officer. So any government medical officer cannot apply for the registration of nursing home. And for the reasons connected with the situation, construction, staffing, equipment, nursing home, or its any part is not fit for the use of such nursing home as described in the application. So these are the structural requirements. situation of that nursing home, there is no parking area, or construction is old, or that building is old, or the staff is insufficient, or required equipment are not present, means if it is a OT and generator is not present, such for on such grounds, this application can be rejected. Again, section 5, uh, in the section 5, in the subsection 2, it is prescribed that uh, subject to the provisions of section 7, the registration certificate shall be in force and valid till the 31st March of the third year from the date of registration. Means, suppose that registration is provided on the 1st April 2025, then it will be valid till the 31st March of 2028. And if the registration is provided on the 1st January 2026, then also it will be valid till the 31st March of 2028. Means maximum 2 years, maximum 3 years, and minimum 2 years. Or maximum 3 years. It will be valid for maximum 3 years. And if the registration certificate should be displayed at the conspicuous place in the nursing home. As usual, this we have also this the similar provision in the PCPNDT Act also. Again, section 6 says that penalty for the non-registration means uh, running a nursing home without registration means violation of provision of section 3. What is that section 3? Prohibition to carry on a nursing home without registration. So if any person carry on a registration without carry on a nursing home without registration, then there will be imprisonment up to 6 months or fine up to 10,000 rupees or both. And again, there is a section 7 in which the grounds for cancellation of registration has been prescribed. So these grounds are same as that of the grounds for refusal of the registration. Means section 5 subsection 1 clause A, B, C, C1, C2, C3 and D, which we have already seen. These are that grounds. Means on the same ground on which the application for registration can be cancelled, can be rejected, the registration can be cancelled. Or second ground is conviction for the offense under this act. The word this act is important. So if that applicant is convicted under the any for the offense under this act only, not any other act, means not the offense of medical negligence, murder or rape or dacoity or any other act, only the offenses under this act. And these are the only grounds on which the registrations can be cancelled, not on other grounds. Means allegation of death due to medical negligence is not ground for cancellation of registration of nursing home. Again, in section 8, the procedure for the cancellation of the registration has been prescribed. So at least one calendar month's notice to the applicant stating intention to make such order, stating grounds for making such order, providing an opportunity in person or by representative of being heard for showing cause for not making such order needs to be given. So what happened before the cancellation of the registration? The applicant, means cancellation of registration or refusal to register, refusal to registration, rejection of application of registration, at least 1 month calendar notice to the applicant or that registered person needs to be given. And in that notice, stating the intention to make such order and grounds for making such order, means why that local supervising authority is cancelling its registration, and providing an opportunity of being heard for showing cause, and why this registration should not be cancelled. This needs to be given at least one calendar month. And after following the procedure prescribed in the subsection 1, if the order of refusal of application of registration or cancellation of the registration has been made, its copy need to be sent to the application by registered post. Means suppose the that's local supervising authority wants to cancel the registration, then it has to give at least 1 month calendar notice to the applicant or that registered person. And after giving that notice and after receiving that reply to that notice, And if the local supervising authority makes this order, then its copy needs to be sent to the applicant by the registered post. And again, appeal against the order passed under subsection 2 can be made to the state government within 1 calendar month from the date on which the order was sent to the applicant. So this is the important provision. So what remedy is available for the order for this order of cancellation of registration or order of rejection of application of registration? So appeal can be made to the state government. State government means health ministry, and the appeal period is 1 calendar month. And section 4 is important. Order passed under subsection 2 shall not come into force until the expiry of appeal period, and if appeal is made in then till the final disposal of the appeal. Means suppose that local supervising authority has given 1 month calendar notice, means that authority has given a notice on 1st January 2026. Then the applicant has to file a time limit to file the reply till 31 January. And after receiving that reply, if that nursing home, that so local supervising authority cancels the registration or reject the application of registration on 1st February 2026, then there is a appeal period of 1 calendar month. Means till 28th February, the applicant can file appeal to the health ministry. And if appeal is made, then till the final disposal of the appeal, means at least during the appeal period, means 28th February, the order cannot come into force, means the registration will not be cancelled till the expiry of the appeal period, means till the 20th February. And if appeal is made in that period, then till the final disposal of the appeal, means stay is not required, only filing appeal is required. This is a good provision for us. Again, section 6 that says that penalty for non-registration, violation of provision of section 3, it is imprisonment up to 6 months or fine up to 10,000 rupees or both. Again, this is section 7, grounds for cancellation of registration, which we have already saw. Next is section 9, which is regarding the inspection of nursing home. So according to the subsection 1 of this section, local supervising authority or its any officer authorized on its order at all reasonable time may enter and inspect premises of the nursing home. And during this inspection, that officer can inspect any records needs to be kept in accordance with the provisions of this act. But that officer or that local supervising authority can't inspect any medical record relating to any patient in a nursing home. Means this authority is not empowered to check the case papers of the patient, what treatment you are giving and what is the name of the patient and all that things. This authority is not empowered to do this. So whenever any authority calls for the case paper of the patient, in the reply we can say that you are not empowered to inspect these case papers. So we saw many cases where where a patient filed a case of medical death due to medical negligence to the local supervising authority, to the civil surgeon, and civil surgeon asked for the case papers. So in such situation, we should inform that you are under this subsection 1 of section 9 of Maharashtra Nursing Home Registration Act. You are not allowed to ask for these case papers. And clause 2 says that any person who restrains any such officer from such entry and inspection shall be guilty of an offense under this act. So we cannot restrain this officer. Again, section 10 is about income of the local supervising authority, expenses of the local supervising authority. Again, section 12 is about penalty of offenses under this act. So for the contravention of such provisions for which no penalty has been prescribed, will be fine up to 5,000 rupees for the first conviction and up to 50 rupees per day for subsequent or continuing contraventions. So again, section 13 says is about offenses by corporation. So if a person committing any offense under this act is a company or corporate body or association of person. So unless proved contrary, every person concerned with its management and at the time of commission of the offense shall be presumed guilty. So this is the presumption of fact. We have already seen this concept in our PCPNDT Act that unless proved contrary, that person will be considered as a guilty. Suppose the CEO of the company, whether he has knowledge or not, it doesn't matter. It will be deemed as he has knowledge of the act and he will be presumed as the guilty. Section 14 about court competent to try the offences under this act. This court is a JMFC, Judicial Magistrate of the First Class. Means if any person is this authority to impose this fine and this imprisonment is to the JMFC court and not to the appropriate authority. Means what happen? If any applicant contravenes the provisions of this act, then that local supervising authority has to file a case in a JMFC and JMFC will give the punishment of fine or imprisonment or whatever it may be. And not that local supervising authority can directly do. Again, section 15 is about indemnity to the person acting under this act. Section 16 is about power to make rule, means government is empowered to make rules for the enactment for this act and power to make bylaws which are consistent with the provisions of this act. And uh, by using this power of section 16 and 17, government can make rule at time to time. Government can prescribe rules for implementation of this act. And last time government had made some rules in 2022 21. Again, section 18 says that this act is not applicable to the government hospital. So government hospital doesn't need the registration under Nursing Home Registration Act. So this is a small act. In the next lecture, we will see about the nursing home registration rules, which were made in accordance with the section 16 and section 17 of the Nursing Home Registration Act. Thank you very much.